Thank you everybody for joining. We're delighted to be here today. It might be afternoon or evening. We've got a few people from Asia joining us, which is fantastic. My name's Lucy England. I'm a travel partner here at Fox Williams, and we have the travel team here today to talk to you about some of the lessons that we've learnt and seen from the last 18 months during the pandemic. There's been a lot of events on the topic. I'm sure many of you have been to them. But today we're hoping to give you a little bit of insight into the legal side, the regulatory landscape. We're going to look at some of what we've called the red lines that some businesses have not been able to cross, the grey lines where there is a little bit perhaps more flexibility, and we're also going to look at the regulators and what we've seen in terms of managing the regulators and giving you some top tips in case you ever need them with the CMA. Just a little bit of housekeeping before we get started. Everyone is on mute and off camera, so we're taking questions through the Q&A function on Zoom. Hopefully you'll see that. Please do send questions through. We will answer them as they come if appropriate, or we'll leave them to the end, but please do ask them. They'll be confidential, so don't be shy. We'll treat everything confidentially with your name. And we are being recorded, and the recording will be available afterwards. We're running this as a Q&A style session. We're delighted that we're all in the same room together for the first time. So we are it's a bit of a fireside chat. That's how we're setting it up. It's a trial for us, so let us know if it works at the end. So the panel today is Rhys Griffiths, the other travel partner here at Fox Williams, who I'm sure many of you know, and our associates in the travel team, Phyllis and Anna. So without further ado, we will crack on with the questions. And Anna, I'm going to start with you. I mean, generally speaking, what impact would you say the pandemic has had on the travel regulatory landscape?
Yeah, so the pandemic has really tested the limits of the law in this area, particularly in relation to consumer law, and specifically to travel, the package travel regulations. In normal times, the legal obligations of travel companies are not tested anywhere near as much. But the pandemic has thrown up a number of unique fact patterns, which have led to questions as to what the legal position is. And as a team, we've spent quite a lot of time analysing that.
Sure. Can you give us some examples, perhaps, of what you've seen and what you've had to grapple with?
Yeah, of course. Questions, for instance, does the traffic light system trigger PTR cancellation rights? What happens if a customer books a holiday to a destination which has been moved from green to amber? What if the customer is prohibited from travelling, but the holiday can still be performed? These have all been tested and developed, and have developed our understanding of how the law works in this area.
So before the pandemic, perhaps let's rewind. What would the position have been, say, on refunds for travel companies? I mean, that's been the big thing in the press. What would have been the position before all of this?
Yeah, so before the pandemic, most travel companies always had the perspective of wanting to look after the consumer first. The mindset of the business was almost always put the customer at the forefront of your mind. And historically, travel companies have been able to offer refunds to customers, even if the customer couldn't go on the holiday. But during the pandemic, that position shifted a little bit.
And how did it shift? What do you think changed?
Well, the impact of the pandemic has been, as we all know, completely unprecedented. And travel companies have been faced with the real prospect of insolvency. They've had a bit of a double whammy because they've basically had to be refunding customers under the PTRs, but haven't had the protection of new bookings. This has meant that they've had to take a more legalistic approach to compliance under the PTRs, and in order to keep trading, they've had to adopt refund policies which are limited to what they must offer under the PTRs, as opposed to the more generous policies that they might have done previously.
So you mentioned the sort of legalistic approach. Rhys, what's some of the red lines that are in the travel regulations that companies haven't been able to cross?
Yeah. Well, I'd say probably the absolute sort of clearest sort of legal red line has been the 14-day refund rule. So, in any situation where the travel company cancels the package because of the pandemic, there's a very clear obligation on the travel company to then refund the customer in cash within 14 days. So that's been the issue, which has probably been, as you said, most widely reported, and is the clearest example of a red line in the regulations.
So with that, I mean, was that red line crossed by a lot of travel companies?
Yeah, it's fair to say, particularly in the early days of the pandemic. I mean, as Anna has mentioned, it was just an extraordinary situation, one that neither of us has sort of faced before with our travel clients, where they were facing down the barrel of failure and insolvency back in March 2020. Huge numbers of packages having to be cancelled, huge refund obligations, no money coming in, no money coming back from suppliers in circumstances where the travel company had paid the suppliers. So, most travel companies just couldn't afford to fund from their working capital the refunds that they needed. So we definitely found that travel companies from the very early days, and maybe for a matter of months, weren't complying with that 14-day refund obligation.
So what did they do?
So I think it's fair to say that there have been a number of different approaches. Some travel companies just took longer. So instead of paying a refund within 14 days, the refund process rolls on. So it could be a matter of months, it could be a couple of months, it could be longer. Some travel company, there was a degree of sympathy, I thought, from consumers and from the regulators in the early days, but that position became fairly unsustainable quite quickly, I thought. So you then had some companies that were perhaps refunding in chunks. So many travel companies obviously keep hold of the accommodation element of the customer's payment, but the flight money's gone to the airline. So some companies were taking the approach where they would refund the accommodation element first, and then they would chase the airline for the refund. And once that comes back from the airline, that would be passed on to the customer. So it's kind of a refund in stages, which is better than nothing. And it's all about trying to manage the adverse press, the consumers, everything else. And then obviously we moved, I think fairly early in the pandemic as well, to situations where travel companies were trying to persuade customers not to take a refund and to take an amendment or a voucher. And that then spawns the refund credit notes thing, which meant that no cash had to go out to the door. And obviously a lot of travel companies were incentivizing the customer to try and take those vouchers. So maybe offering a refund credit note, which was worth 110% of the value of the holiday, as opposed to a refund. And then obviously there were some companies that probably suffered the worst PR and most attention perhaps from the consumer associations and everyone else, where they were only offering vouchers and no sort of cash alternative as well. So we saw a mix of those approaches from clients, I think, just to try and manage and find a way through the real prospect of insolvency.
And even the European Commission made a statement as well. I mean, did that help, do you think?
I think so. I mean, it was surprising actually to have something like that from the European Commission, which is usually incredibly pro-consumer. But I think even they wouldn't go the extra step that some member states were asking for, which was that they suspend the 14-day refund obligation. And similarly, the airlines were asking for the Regulation 261 refund obligations to be suspended. Some member states even decided to do that kind of unilaterally, but the European Commission wouldn't go that far. But I think they felt that they went as far as they were prepared to go in issuing notices to try to encourage consumers to take vouchers.
So what did you see as some of the consequences of the travel companies not paying the refunds in the 14 days that they legally had to?
I mean, the consequences were, some of them legalistic, some of them weren't. So obviously, in the early days there was some sympathy and some tolerance for travel companies not refunding within 14 days. I felt that disappeared quite quickly as consumers wanted refunds. So there was quite a bit of adverse PR around it. Naturally, consumers were complaining on social media to the consumer associations, Which Magazine, BBC Watchdog, all of these sort of consumer bodies. That then, I think, ultimately led to consumers making chargebacks, which was one of the other consequences for travel companies. And many travel companies, including those who thought that they had a low risk agency model, were finding themselves kind of responsible for chargebacks, even though they were acting as an agent in the transaction. So chargebacks was a huge part of it. Some consumers then went down the small claims route, and particularly with lots of people being at home, lots of people being on furlough, the ability of customers to start these claims through the online portals meant that some travel companies were getting lots of these small claims things. And then, the other one as well is regulatory action, ultimately by the CMA primarily, who, whilst the CAA also had jurisdiction in this area, I think they've decided amongst themselves that the CMA would take this on. So we then started to see the CMA start by taking some sort of soft enforcement action by issuing letters of open letters to the industry, but that then moved to enforcement action against a limited number of travel companies.
Yeah, which we'll come on to. In the small claims thing is an interesting one. It's obviously open to consumers, and we've seen our clients having to deal with it. Do you think that's settled down now, the small claims? Phyllis, I don't know if you've got a view on this.
There was a point where, for at least a couple of clients, it seemed inundated actually with small claims. So yeah, I would say it's definitely calmed down now, and that's probably because the travel companies have been much more on top of issuing refunds. They're issuing refunds much quicker than they were before. And so yeah, for one particular client that I can think of, I don't think we've had any new small claims in the last, maybe this year, even late last year. And by that point as well, we were sort of settling those claims quite quickly. So before it got to the stage where we would be going to court for a date, that it would be settled with the client and with the customer, sorry, and they would receive their refund in full, plus legal costs and things like that. So yeah,
there's the incentive to not let it get that far.
Yes.
Yeah. Okay. So we talked about red lines. Let's move on to the less strict parts of the regulations. Rhys, what are some of these grey areas that we mentioned at the beginning?
Well, the grey areas, seems to me, all revolve around a situation where the holiday can actually be provided, in the sense that the flight hasn't been cancelled, the hotel's still open, and it's a situation where the customer either can't travel or doesn't want to travel. So we're sort of looking at scenarios like situations where the FCDO advise against travel, in circumstances where the airline hasn't cancelled. So the holiday could still go ahead, but the customer no longer wants to travel. And then there were similarly situations where the customer might have to satisfy certain entry requirements at the destination. So more recently, we've had situations where certain countries will either refuse entry unless you're double jabbed, or will impose some form of quarantine requirements on entry unless you're double jabbed. So there are those sorts of entry requirement scenarios, and which customers might have the opportunity to comply with. So then there's an issue about whether they should get themselves double jabbed so that they can take their holiday. And similarly, I think the other big one has been situations where customers have been locked down. So I think it started with Leicester, where customers from that part of the country were prohibited from leaving Leicester. So the holiday could be provided. So we that is another sort of scenario which I think falls into the grey area.
Interesting, yeah. Leicester's my hometown, by the way, so I have an affiliation with it.
I wasn't going to be rude about it, Leicester.
You mentioned FCDO advice, which has been another hot topic. In pre-pandemic, how was FCDO advice treated?
Yeah, well, from a legal perspective, it's been one of the more debated issues and one of the more interesting issues, I think, to come out of the pandemic. So pre-pandemic, there was this convention within the industry that whenever the FCDO advised against travel, customers would be offered full refunds. And that was certainly the ABTA approach, and all of their members were expected to follow that rule. And I think pre-pandemic, that might have been easier to implement because airlines may have cancelled the flights as well. Something which has been different to post-pandemic. That convention has never been the legal position under the PTRs. The customer's right to cancel in circumstances where the holiday is operating is very specifically set out in the PTRs, in Regulation 12, which basically says the customer can cancel if some situation has developed in the resort, obviously after they've booked, which has significantly affected the package in some way. So it's obviously a grey area, because in order to assess whether that right has been triggered for a particular customer, you have to look at the circumstances of that particular booking. So to figure out whether the package has been significantly affected post-booking by something that's happened in resort. So that's going to depend on looking at things like when did the customer book, was the pandemic already on foot at the time of the booking, what was included within the package, because what has to have been affected is what is in that package, and also circumstances such as the characteristics of the particular customer. So those with underlying health conditions are probably more vulnerable to the pandemic. So you could say that, well, it's more of a safety risk for those sorts of customers than it is for younger customers who have been double jabbed. So it's because the actual legal test is much more nuanced than the historic convention of just following the FCDO advice.
It's an interesting, so we call it a grey area. Does it give flexibility? It's not so much that it gives flexibility, but there's less clarity in some areas, which can benefit the travel companies.
And that works both ways, doesn't it? It's particularly in the circumstances of the pandemic, and in circumstances where the airlines were operating flights and weren't cancelling. I think many travel companies then took the view that, well, we can't afford to fund the refund of the flight cost, so we're going to have to look more closely at this FCTO issue and what the obligations are under the PTRs, because otherwise, if we just decide to refund all customers because the FCDO has advised against travel, particularly in circumstances where the FCDO advice was heavily criticised in the early days because of the blanket nature of the advice, I think it probably cut both ways in that sense.
I think there's been a bit of travel companies having to educate themselves, find their own policies, and then having to relay that to consumers in the right way.
Yeah, and I think let's not forget that what the issue really revolves around is whether the customer is offered a full cash refund or not. Most customers are offered the full value of their package in some way, because I think in our experience, most customers are offered a voucher for the value of that booking. So the choice for the customer is, if they opt for the cash refund, they won't have the flight cost back unless the airline subsequently cancels. But they will usually have a voucher from the airline or an ability to amend the flight. And the alternative option is that they just take a voucher from the travel company for the full value of the booking, often, which means that they can amend. So it's a grey area. It's an imperfect outcome for some customers because they won't get a cash refund. But I sort of think, well, it's not a bad outcome that you do keep your holiday. You just have to take it at some other time.
Yeah, yeah. And do you think there's a consensus on FCDO advice now? Has it settled down?
I think there's largely consensus on the legal position. Yeah. I mean, in the early days, the CMA went out quite hard saying FCDO advice automatically triggers full refund obligations. They have changed their position on that now, so it's more aligned with the PTRs. So referencing the test in the PTRs, but obviously emphasising the relevance and the importance of FCDO advice, because it's certainly an important indicator that there's something going on in the resort which may trigger the customer's full cancellation rights. But I think the legal position is pretty settled. I'd say ABTA members have obviously additional obligations under the ABTA rules, and I'd say whilst ABTA has changed its code of conduct on this to contemplate that there are situations where if you're clear with the customer at the point of booking on what your cancellation policy is in these circumstances, then you may not be required to refund the customer. But I think that is certainly an exception as opposed to the general ABTA approach, which is still FCDO advice means full refunds.
Okay, so might be more to come on that.
Yeah.
Okay, let's move on now to sort of the regulator and the CMA. Phyllis, what have you seen generally in terms of enforcement action from the CMA? Some of it's been public, but yeah, let's remind ourselves what's been out there.
Yeah, sure. We've seen that the CMA has taken enforcement action against 5 travel companies. Of the actions that we've been involved in, these have been situations where the customer, there's been no dispute basically that the customer is owed a refund. Typically the organizer has cancelled the package, and so under the package travel regulations, the customer is owed a refund within and has to receive a refund within 14 days of the date of cancellation. The problem is a lot of the travel companies haven't actually paid those refunds within 14 days. Or some of what we've seen also is that those travel companies have been issuing refund credit notes or vouchers, and they should have also been giving the customer the option to receive a full cash refund, but they haven't done that as well.
So the CMA, obviously in the press a lot, but what powers do they actually have?
So they have 2 types of powers. So they've got criminal procedures that they can use, and they can also use their civil procedures. And for the cases that we're aware of, the CMA to date has only used its civil procedures so far. Yeah.
And what, for those that don't know, does an investigation look like? What form does it take?
Okay, so generally a CMA investigation can be split into 3 stages. The first one is the information gathering stage. So this is where the CMA will write to that relevant company. They'll tell them that they suspect that the company is breaching consumer law. And on that basis, they're going to open a formal investigation. Then they'll send the travel company a very kind of long, detailed information request. and that it's then for the travel company to kind of gather up all that information, give it to the CMA, and then the CMA uses that information to determine whether there's been a breach of consumer law of some kind. This process usually takes a number of weeks. It's quite long-winded, if not a couple of months sometimes. And also during that process, the CMA can follow up with additional information requests. So there's a lot of back and forth basically between the travel company and the CMA. And then there's a second stage, which is settlement discussions. So if it has been established that there has been consumer breach of some kind, the travel company is then given the opportunity to avoid any kind of legal action, possibly through the courts. And they usually do this by giving formal undertakings to the CMA. And in those undertakings, or those undertakings will basically set out the steps that they need to take to remedy that consumer law breach. And of the 5 companies that we've seen so far that have the CMA have launched investigations against, they've all given undertakings so far, so there's been no legal action.
Okay. So what sort of form do those undertakings take? What do they look like?
They can be quite, let Rhys chip in here as well, they can be quite long, a lot of them. There's some formal wording that will be in there that will make it really clear to the company that they've breached particular consumer laws. And then it gets to the kind of practical element of it. So what is the travel company prepared to do to remedy that breach? And it could be a whole range of things. Hopefully the travel company will be in discussion with the CMA about how to tackle that breach and what actions it can and what it's prepared to take to do that. And then that will all be set out in the undertakings, and there might be specific kind of one-off things that they have to do. And then in addition to that, there might be some sort of like regular reporting and things like that, which is actually helpful, comes on to the third stage. So of the 3 stages, the third one is the monitoring by the CMA. So they want to monitor that whether the travel company is complying with the terms of the undertakings. And that's usually done by asking the travel company to submit regular reports to the CMA. I think Rhys and I have also seen that during that time, the CMA, if it receives some information that it doesn't necessarily like, it might randomly ask for some additional information from the company. So that could all happen during that third stage.
And I mean, the CMA, Rhys, what's your experience of the CMA? Are they open to negotiation? Is it, a one-way street, let's say? Or, what have you learned?
Well, I think you have to realise that the CMA have a job to do. There has been much unhappiness within the travel industry at the lack of government support, tailored support for the travel industry, which is obviously an accurate criticism of the government. However, the CMA isn't responsible for that. The CMA see themselves as rightly being responsible for enforcing consumer law, and they will be concerned about making sure that customers are offered refunds and pay those refunds if they want. So that's their focus, and you've got to accept that. You're not going to persuade the CMA that the consumers aren't entitled to refunds if that's what they want. In terms of the approach for the CMA, I mean, there are certain red lines, I think, for the CMA. Like I said, they are interested in getting refunds for consumers in these cases, or at least the option of refunds. I think there is a degree of sympathy, is probably the wrong words, but there's a degree of sympathy to the situation of travel companies. They have obviously been the worst affected by the pandemic. They are obviously unable to pay these refunds within 14 days. So I think where there is scope to maneuver is around how long the company has to pay refunds, historic refunds to consumers. And we've seen, because the CMA doesn't want to be responsible, I don't think, for putting companies into insolvency. So it is trying to weigh in the balance the interests of the consumer, and so ultimately it's probably not in the interest of the consumer if the travel company fails anyway, because then the consumer has to go to Atoll. There's a whole process there that takes a long time. So I think the CMA is just trying to find balance, but absolutely will give travel companies longer to pay the refunds, but they do want those travel companies to pay the refunds at the end of the day.
Do you think that the CMA has been quite light touch so far? Is there more to come?
I think with the travel companies, the cases that the CMA has brought so far have been the easy wins.
Mm-hmm.
So it's a little bit like shooting fish in a barrel to say that, because they have focused on situations where the travel companies have cancelled and haven't paid the refunds within 14 days. That's black and white. That's very, very clear in the regulations. There's no legal defense to that. So it really, so those are easy wins. It then is just a case of negotiating undertakings and deadlines for paying refunds. I think the cases they haven't brought, which they could have brought, are those which are in the grey area. So around the approach of travel companies to the FCDO issue, the approach of travel companies to situations where customers have been locked down, and those other sort of grey area situations under the regulations where the CMA could have brought those claims, but has so far decided not to.
So investigations are potentially the worst thing that could happen. What else has the CMA done to help themselves with them?
Yeah, well, I think the CMA uses quite a practical means of achieving enforcement, as well as the legal means that we've been talking about, and its main practical tool is the use of press notices and press releases. And there are loads of different reasons why it does that. Whenever it obtains undertakings or starts enforcement action, or thinks that a particular company hasn't complied with undertakings or isn't doing what it wants it to do, in all of these situations, it'll issue a press notice. And I think one of the reasons for doing that is to tell the public what they're doing and to engender confidence in them as a regulator, so that they are seen to be doing their job and looking after the customer. So it serves that purpose, but also obviously other travel companies are seeing what's happening. The CMA doesn't have the bandwidth to take everybody to court or to seek undertakings from everybody. These investigations are pretty substantial, even for one travel company. There's lots of information, there's lots of correspondence, there's lots of negotiation with the lawyers to get to a stage where there's agreed undertakings. So it just doesn't have the bandwidth to do that for everyone. As Phyllis said, there have only been 5 of these investigations so far in the travel industry. So what it will do is publicize enforcement action against those companies it does take action against, in order to act as a deterrent for other travel companies, because nobody wants to be in that situation. So we've seen plenty of that. And then obviously the last thing is when you are dealing with an investigation with the CMA, there is always the prospect that which they will leverage off, that if you can't agree things amicably, the consequences for the travel company can be quite severe in terms of the adverse press of enforcement action or a court claim or criticism from the CMA. So this prospect of there being press release from the CMA does hang as a sort of Damocles over these travel companies' heads.
Mm-hmm. Yes, it's a clever way of doing things and works to their advantage, which is the point. Okay. I think sort of we've had some questions in. Please do send some more. We have time. So what I think sort of to finish off my questions is, in terms of dealing with the regulator, Phyllis, what's your top tip for dealing with the CMA? So.
Well, the best way of dealing with the CMA is to try and avoid their enforcement action, actually, if you can, in the first place. But the best way, in all seriousness, to do that is, or one of the ways to do that is just to avoid coming under the radar of the consumer action groups and the consumer associations. So the likes of Which and Money Saving Expert, BBC Watchdog, etc. They're very, very influential for the CMA, so they take notice of who, who's being complained about the most. And what we've typically seen is that a company will probably receive a letter from the CMA after there's been some sort of press article about that company. So yes, big tip.
Yes, it's a good big tip. And what are the ones? Have you got any more?
Yeah, well, in terms of dealing with the CMA itself, I'd say our best advice is, if they ask you for information, make sure you give it to them, make sure that it's accurate. If it's not accurate, this will undermine the CMA's trust in the travel company as you're dealing with them. And also it makes it more difficult to reach a kind of a preferred, or negotiate with them to reach a preferred outcome of the investigation. Another really practical tip, and one that's been really useful for us actually, is don't be afraid to initiate any dialogue with the CMA. So don't be afraid to ask them to have a call to discuss the investigation, or even the content of the undertakings. I think we will agree, we've noticed that they're quite cooperative in that sense. They're quite open to suggestions. And then on the issue of refunds itself, I'd say our main tip is to make sure that you're really open about your financial situation. So if you're going to ask the CMA to give you more time to pay the refunds, then the CMA will want to know why. If there's an issue with the time frame for making refunds to customers, you should say that. Is it going to be realistic enough for you? Those sorts of practicalities. And also they will be keen to know how you're going to source those refunds. So how you're actually going to pay for those, where's the money going to come from? So those would be our main tips.
An interesting one that you say, you can talk to them. It's not a sort of one-way dialogue. That's what they're there for. Yeah, that's a good one. Okay, so we have had some questions through, thank you. The first one I'll start with is, can insurance help with any investigation costs? Interestingly, Rhys.
I guess so. I guess this question is what insurance against what the legal costs of dealing with CMA investigations.
Yes.
Well, I mean, there are insurance policies out there before the events, insurance policies for dealing with investigations and legal costs and that sort of thing. I mean, you can have that for all sorts of different legal inquiries, civil, criminal and regulatory like this. So I'm not an expert in this area, but I imagine that, I mean, we have actually had experience of clients claiming legal costs against insurance for criminal and civil investigations in the past. So I don't see why for something like a CMA investigation that there might not be insurance for that kind of cost. So I presume so, although I'm not aware, I'd say, of clients. I mean, it's not to say that they haven't, but I'm not aware of clients having had these insurance policies in the matters we've been dealing with.
Specific ones, yeah. Okay. We've had it's a comment rather than a question. I'm going to share it because it's a very good one, so thank you for sending it in. They're from a flight-only agency. You mentioned civil money claims being brought against travel companies by customers. This company has been using that same process to bring claims against customers who've abused the chargeback process, bringing chargebacks against the travel company for flights where no refund was offered by the airline. Some chose not to travel, some were cancelled, others they also received a refund. So the customers that have received a refund and have been dishonest about it, the travel company has used the civil money claims scheme to recover that money, where the travel companies also made the refund. So
Yeah,
that is that's, thank you for sending that. I mean,
that's interesting. I mean, we've had this issue a lot, and Anna's been helping with this strange situation for travel companies to find themselves in, where legally they position themselves as an agent. So in this situation, the customer wouldn't have a legal claim against the flight only agents for some failure to provide the flight. The claim is against the airline, yet they've been able to initiate chargebacks against the agents on the basis that they're the merchant of record, and the Visa and MasterCard scheme rules will allow chargebacks in that situation. And I know that there were some discussions on this early on with Visa and MasterCard to try and explain that they were effectively interfering in the legal relationship between the customer and the travel agent, and effectively overriding what's been agreed. So I mean, there have been talk about travel agents making claims against customers in those circumstances on the basis that, I mean, particularly if the customers receive something from the airline on the basis that the customers being unjustly enriched, seems to be the main ground that people have been relying upon. So I think it's something which is really unsatisfactory in the travel industry, in how chargeback rules, particularly for agents, don't necessarily reflect the agreed legal position between the customer, the agent, and the principal.
It's an interesting dynamic, and this next question sort of links to that as well. Regarding refund obligations of the airlines to the travel agent rather than the customer for cancelled flights, is the obligation dependent on the contract between the airline and the travel agent rather than anything, I guess, to do with the PTRs and regulations?
Yeah, I'll give a quick answer. I don't want to hog the.
It's quite all right.
We're doing a lot of work in this area, as you know, and acting for travel companies bringing claims against airlines to get money back. There is a claim you can make under the package travel regulations. So if you're a tour operator, if you're an online travel agent, you sold a package to the customer which includes a flight. You've refunded the customer, but the airline, which has cancelled the flight, hasn't refunded you. So there's a claim you can make, an indemnity claim you can make under the PTRs. There's also more complicated, and I won't go into this, but unjust enrichment claims that the intermediary can make against the airline. And so far, we've seen that these claims have been limited to certain well-known airlines, where for some reason the travel company hasn't been able to initiate a chargeback against the airline, because that's been the first port of call, is really making chargebacks on the virtual cards. So, and just only in situations where maybe the chargeback's out of time, or maybe the particular scheme doesn't allow chargebacks in these situations, the travel companies then have to look at making legal claims against the airlines to get their money back. So, I mean, there's definitely, so there's certainly avenues. Usually the concern is obviously about the cost and the undertaking involved in bringing a court claim against an airline, particularly when money is quite tight anyway, for the travel company to then spend a load of money chasing airlines is, some people will just suffer the loss and think, look, we need to prioritize elsewhere.
you know, if the collective quantum is enough to justify it, but you know, £50, £200. I think the answer is yes, it is a contractual claim, but it's whether it's worth it. Time and cost wise.
Yeah.
Okay. Yeah. A couple more. One that's just come in, actually, I'll move on to these other ones. What about the other regulator, CAA? A well-known travel accountancy firm recently described the current renewal period as bedlam. Are we seeing these challenges amongst our clients, particularly the sub 20 million Atoll holders, and the asks being made of them by the regulator?
So I think I know who the accountant is. I think the Atoll renewal was extremely tough for lots of companies. Whilst there's this consultation going on at the moment about moving Atoll holders to trust accounts, you know, it has been happening under the radar. Lots, if not most, of our travel clients have been asked at the last Atoll renewal season to put customer monies in trust. I suppose, you know, the CAA doesn't like the risk profile of these companies. There's a concern that obviously there's a lack of capacity in the bonding markets. But as far as I can see, it's the worst possible time to ask travel companies to recapitalize the business so that they can put the customer cash in a trust account. So it's, I mean, the negotiations, and you know, you have, I think, yeah, travel companies have been coming under attack, might be the wrong word, from all sides. CMA with their investigations, CAA asking for money to be put into trust accounts, merchant acquirer asking for security. So it's just been a constant battle for travel companies over the last 12 months, and it doesn't seem to be getting any easier, with concerns that we might see another cycle of this winter. So I mean, I share the concerns of whoever sent that question as to the last Atoll licensing rounds, for sure.
Yeah, there's probably more to come. And on that, I mean, the last couple of questions, you know, looking ahead to the next 6 months, you know, is it going to be a happy winter, or, you know, winter of discontent for travel companies again? I mean, Anna, what do you think is going to happen?
I think there's a strong possibility that it's going to be a little bit more like a winter of discontent. Hopefully it'll be a bit easier, as there won't be so many people traveling perhaps, but it's hard to tell. Rhys, what do you think?
I agree. I think there's a strong possibility. You see where the numbers are going. You see scientists coming out saying there might need to be, I mean, I'm not an expert, but the stuff I read in the press tells me that there are going to be some measures to restrict movements later this year. If that's happening in the UK, that could be happening overseas. So, you know, with the Delta variant, with other variants, it's a constant race, I think, between vaccines and the virus, and we could end up, I mean, maybe hopefully not on the same scale as what we had before, but I could certainly see ourselves having another cycle of dealing with the same issues that we've been dealing with over the last 16 months, over the next 6 months.
And maybe consumers as well sort of have heard about these claims being made in the press a bit more, and have sort of an imbued sense of confidence to maybe make a claim against a travel company as well.
Yeah, I agree. You know, the knowledge on chargebacks, even for debit card purchases, has been enhanced. So, you know, consumers, I think, are more aware of their rights. And, you know, whenever there are chargebacks, there are then problems with the acquirer feeling exposure. So, yeah, and I think, you know, obviously as we move through more Atoll renewal seasons, there are then going to be more demands for money to put into trust accounts. And even those that already have trust accounts, you know, maybe they're only putting some money into trust. I think those requirements would probably increase. So we go from, instead of putting 50% of customer money into trust, next time round it'll be 70, and the next time it'll be 90.
I'll just add though that you would hope you know, this time round, travel companies will be a little bit more prepared for what's coming up. I think it's been a massive learning curve for everyone, and obviously the situation was so novel and so kind of out of the blue, nothing compared to what we've seen before, even with ash clouds and things like that. So I think a lot of lessons have been learned by travel companies, and hopefully they'll be better prepared for what's coming up. And as Rhys said, hopefully it'll be much smaller scale this time, with lots of people being double vaccinated and things like that. So
yeah, no, you're right. One final question, I think, is the C word has been used a lot. The B word, Brexit, has been completely ignored for the last 18 months to a large extent. Do you think now that we've left, there's obviously the changes to the PTRs, and the question isn't around that. I don't think it's more, you know, as the UK now has the opportunity to do things on its own outside the Package Travel Directive. Are we going to use anything to become a little bit more trade friendly away from consumer friendly, do you think, or is this not going to change for the foreseeable? What's your view?
Politically, I think it's quite difficult for any government to roll back from the existing PTRs. There might, I think, there might be tinkering around the edges. I think that the parts that would be particularly nice to be fixed is the disconnect between Regulation 261 and the PTRs. So this situation where there's a crisis, you know, the FCDO advise against travel, so travel companies are being asked to pay refunds, but then the airlines might still operate, and that sort of lacuna in the regulations is probably been one of the major problems actually for travel companies, because obviously if the refunds flow back down the chain, then it all works, but the sort of the scheme breaks down when the money stays with the airline, and then the OTA then, or the travel company, the tour operator, then has to fund that refund to the customer. So there are things like that that would be nice to see fixed. I mean, who knows what will happen, but I don't know. I don't think that we're going to see any massive relaxation in PTRs. That would be my guess.
Yeah, I think that's my view as well. I think the PTD is up for review in the next year or so, but that's the natural course of EU legislation being reviewed.
Yeah.
I think the UK will still probably ride off the back of that for the time being.
Yeah.
There's the airlines insolvency review, which goes alongside all of this. So there's a lot in the melting pot.
Yeah, and there's more. There are other consumer law changes coming in the pipeline, which look to impose more sanctions, not relax the sanctions for travel companies. So, I mean, we're going to be doing other sessions about those things coming down the pipeline. But I mean, I think what we're seeing is that there's going to be more regulation and not less, and more kind of severe regulation of those that don't comply.
Yeah, definitely more protection of the consumer. That seems to be at the forefront of people's minds.
Right, well, that was a good plug for what we're going to be doing in the future. And my other one is to say, please do let us know what you would like us to talk about. We've got ideas, but we'd love to hear from you. I think we'll draw it to a close there. I would like to say thank you very much to my panel for answering all of the questions very well, and for your questions as well. It's great to have them. It's been fantastic having you here, and we hope to see you very soon.